Thank you very much, and thank you for having me today. I must say that I have a connection with the Hague Convention because I studied under David Hayton, Professor David Hayton, who was part of the delegation for the UK back in 1985. So I do have a bit of anecdotes to share with you. I've got a couple of slides, so I'm going to share them if you don't mind. And I wonder if I can go on presentation mode. I can't hear. Just give me a second. Right. I think that we need to see how we got here in terms of looking how the convention was developed and what happened since 1985, and then look at some challenges, but also some opportunities, because I was asked, in addition to looking at the sessions in this track, to look at what lies ahead, what opportunities that might exist for the convention going forward. And as you will see, there are, in my view, a number of exciting opportunities. So how we got here? Well, in this conference, we had a session about the attitudes towards trusts and analogous institutions. The convention is such that there has been a discussion among scholars as to whether the convention should only really capture common law trusts, or whether the convention should actually be used as a platform for the international recognition of fiduciary contracts, foundations, and other analogous concepts. We also then had two sessions on the jurisprudence, case law, in relation to the Trust Convention since 1985, and that's quite exciting. And then how we got here in terms of the convention itself. Well, the convention is not a standard HCCH convention, because normally what you find in Hague conventions, it's connecting factors in relation to an existing problem. For example, the choice of law contracts. Now, the peculiarity of the Hague Convention is that also it needs to deal with the beast that it's dealing with. So the trust mechanism, what is a trust? Because half of the people who were there at the conference knew trusts inside out. The other side of the room was filled with notaries and professors coming from jurisdictions that did not know what a trust was about. So the convention is peculiar because in addition to connecting factors, it contains a description of the mechanism and also a recognition. And there is also a partial overlap between the description in the first part of the convention and the recognition. And then there are also enhanced safeguards. Every Hague Convention has a ordre public policy clause, a fiscal clause that says that taxation is not covered by the convention. But with trusts, there was a concern amongst non-trust jurisdiction that a trust might be used to effectively sidestep a number of very important provisions of domestic law in relation to creditor protection, to forced heirship, matrimonial property. So that's all consolidated in the convention. So not your standard convention. Interestingly, Article 3 of the convention contains a description of the mechanism rather than a definition. If you look at paragraph 36 of the explanatory report, it says that delegates felt that it was impossible to provide a definition of a trust, and that several delegates actually fought against the idea of defining a trust. And that, in a way, is a bit of the challenge, but also an opportunity for the convention, because if you try to propose an international convention to countries that do not have the trust concept, and you do not give them a definition in circumstances where professors, scholars, government officials are used to having definitions, you might have a bit of a problem. So what Professor Hayton told me as an anecdote is that the first day of the conference, the civil law lawyers they looked at the common law lawyers, Canadians, Brits, and said, look, we are here to talk about trust. Can you tell us what a trust is? And one of the common lawyers stood up, provided a definition, and another common lawyer disagreed. And he said, no, a trust is not that one. And so there was a bit of a intellectual fight, with good humor amongst the common lawyers. And the civil lawyers said, look, we are going for lunch. When we come back, we would like you to see a definition. And in reality, what the common lawyers did, because they are pragmatic, they came up not with a definition of a trust, but in Article 2, you have a description of the mechanism by reference to main characteristics. It's a bit like an elephant. You may try to define an elephant, or you may try to say, well, an elephant is an animal, a mammal, with a long trunk and big ears. And that's what Article 2 does. And that's great. It reflects a common law way of dealing with things, but it also provides with some challenges. Because without a definition, people on the other side of the civil law common law divide usually believe that a trust splits ownership. Now, common lawyers refer to trust as having legal title in the hands of the trustee and so-called equitable ownership in the hands of beneficiaries. Now, equitable ownership already requires a description of what is equity and equitable. It goes back to English legal history. But the problem of the perception of a trust splitting ownership is that a number of countries say that is not possible. In our system, you cannot split ownership. You can have maybe limited rights in rem, like rights of passage, rights of light, but you cannot split ownership. And that has led actually to a hindrance in the recognition of trusts beyond the convention. So, for example, if you look at Spain, there was a decision in 2008 concerning a gentleman who died in Arizona, an American. He left a property in Madrid on testamentary trust for his wife, and the daughter took the wife to court, suggesting that the arrangement violated Spain's forced heirship provisions. In those days, the estate of individuals was governed by the national law, so US law applied, and therefore the Spanish court had to consider whether the trust was valid. And the Spanish court effectively said, look, we don't really understand what this trust is. They made reference to the Hague Convention, and they said, and therefore, Spanish law apply, and Spanish law does not recognize a trust because of the split of ownership. There's also an oldish judgment by the German Supreme Court, where the German Supreme Court said that the trust mechanism is incompatible with the dogmatic foundation of German law. And why is it? Because they say that the Anglo-Saxon trust splits the ownership of the trust into legal ownership and equitable ownership, and they say that is incompatible. I've also found a recent PhD thesis from 2018, where the candidate said that the property situation under the trust mechanism collides against the principle of Austrian law. Again, the idea of split ownership. And this challenge stems from the fact, in a way, or is not helped by the fact that the Hague Convention does not contain a definition of a trust, nor does it explain how the property position is dealt with. Now, although common lawyers refer to the equitable ownership as being in the hands of beneficiaries and title being in the hands of the trustee, modern decisions in England and elsewhere show that the position is a bit more complicated. These are all decisions that were handed down after the Hague Convention was adopted in 1985, and therefore they are useful to the extent that they might help a future reframing or cleaning up of the convention in order to deal with a great misunderstanding. So if we look at some modern English cases, in a decision called Pugachev, where the court was asked to consider whether a freezing order against the assets of a Russian banker extended to the assets held in a trust established by him, under which the beneficiaries did not have any right to receive ownership, distributions, a discretionary trust. And the court says that without more, a beneficiary under a discretionary trust does not have any property interest. There was also a recent decision by the UK Supreme Court relating to the effects of a Cayman trust in relation to shares in 5 Saudi Arabian banks. Now, Saudi Arabia does not have the concept of trust, and therefore it was not possible for the trustee to own the shares as trustee in Saudi. Nevertheless, the Supreme Court felt that the trust was valid and binding because the court said that the obligations of the trustee and the jurisdiction of the court of the trustee are actually in personam. He has a obligation to hold assets in a certain way. So the court said, we don't have any problems in saying, although the question of the nature of beneficiaries' right is difficult, it's a difficult question, we believe that even if the trustee does not have title over the assets as trustee because the local law does not allow it, there is a trust. There is also a decision by the European Court of Justice in a case called Webb and Webb, where the Court of Justice of the European Union had to consider a argument between father and son. The son had bought a property, a flat in France. The father believed that the son was holding the flat as trustee for him, and the son said, well, you have to sue me in France because we are talking about property. You are talking about equitable ownership. And under the EU rules, if you're dealing with claims in relation to real estate, you have to sue in the country where the real estate is situated. But of course, the son felt that given that France did not ratify the convention, if the father had to sue in France, he would lose. So the question was referred to the European Court of Justice, and the European Court of Justice said that the fight between father and son, even if it related to a flat in France, was not a fight in relation to rights in rem. So the position in English law is that beneficiaries have a interest of sort. It's property in the way English lawyers talk about it, but certainly is not proprietas, ownership, in the way civil lawyers refer to ownership. For civil lawyers, ownership relates to usus, fructus, and abusus, i.e. the ability to use an asset and even destroy it. And the modern English cases have indicated that under discretionary trust, beneficiaries do not have that kind of ownership. So dealing with that great misunderstanding and saying that trusts create 2 categories of ownership in the scheme of common lawyers, but the ownership is in the hands of the trustees firmly in the eyes of civil lawyers, it's an important factor of how the convention might, I believe, bring more participants. If you want more information, there's an article that I wrote in relation to the new Swiss trust law. It's a proposal, and in there is a discussion about the meaning of equitable ownership. And then another challenge for trusts, and why perhaps only 10 civil law jurisdictions signed up to the Hague Convention is that trusts are perceived as being dodgy. And I have put up there a quote from a French member of parliament who suggested the introduction of a public register of beneficial ownership of trusts. By the way, the Constitutional Court in France later said that a public register of trusts went against fundamental rights. But anyway, when he suggested the introduction of that register in 2013, he said that the creation of trusts gives rise to massive tax evasion. And he went on to suggest that according to Transparency International, 80% of the world's illicit flows linked to tax evasion went through trusts. Now, that is a very flippant statement, because there isn't a register of trusts. Nobody knows how many trusts there are in the world, and therefore to suggest that 80% of tax evasion goes through trust cannot be right. But it reflects a anxiety in the mind of a lot of government officials, especially in the past. We're talking 1985, that trust might not be a good thing. But a lot has happened since 1985. We have the Common Reporting Standard and FATCA. These are systems of automatic exchange of information signed up by over 100 jurisdictions. And effectively, if you got a trust and the trust has got a bank account in a different country than that of the settlor or the beneficiaries or the protector, the bank or the trustee must report the value of the account to the authorities, to the tax authorities of the country where the beneficiaries of settlor is situated. And if you look at the Common Reporting Standard, which has been developed by the OECD, the Organization for Economic Cooperation and Development, a lot of ink has been written on the treatment of trusts. So around 100 jurisdictions now, they do understand trusts, and also the inclusion of registers, central registers of beneficial ownership of trusts in the EU under the 5th Money Laundering Directive shows that trusts can no longer be used for tax evasion. So I think that the basis has been laid for a acceptance that trusts are mechanisms that are not used or cannot be used for tax avoidance. And that brings us to the opportunities for the Hague Convention going forward. I think that the first opportunity is to clean up the wording on the convention. So the word equitable ownership, which common lawyers use to describe the interest of a trust, is not really described in the convention. The convention says that title to the trust assets stands in the name of the trustee, and then the trustee administers the assets for the benefit of beneficiaries. And I wonder whether a tighter wording of Article 2, or perhaps an expanded explanatory report, might overcome the misunderstandings of the kind that we've seen happened in Germany, Spain, and in Austria in a PhD, which do not reflect the real essence of a trust. I think there is an opportunity there to effectively make trust clearer to non-common lawyers. There is also the use of the word patrimony in the convention. So if you look at Article 2 in the English version, the convention says that the trust assets are not part of the trustee's own estate. Now, if you look at the French version, it says that the assets do not form part of the patrimony of the trustee. Now, patrimony, it's a word that is used by civil lawyers. It's actually Roman law word. And indeed, the Article 11 confirms in the French version that the assets are in a separate patrimony. Now, in Scotland, which is a hybrid jurisdiction, in part is common law, in part is not, the Law Commission that was tasked to look at the nature of trust did say that as a matter of Scots law, when a person becomes a trustee, he acquires a second patrimony, this dual patrimony theory. Now, that's all very interesting, but in the eyes of a civil lawyer, if you think that a trustee has got a separate patrimony, you may think that the assets of the trusts are protected from personal creditors of the trustee, and that's right, absolutely correct under English law, for example. But you might have the perception that the trust assets are also, sorry, that the trustee's personal assets, his own personal patrimony, is protected against claims made by creditors of the trust. You would have thought, under the dual patrimony theory, the creditors of the trust can only go against assets of the trust. And that is quite dangerous, because as a matter of English law, the concept of patrimony is unknown. And there is a recent judgment, again, all stuff that took place after the Hague Convention 37 years ago, where the Privy Council, which is the top court for decisions in a number of countries that used to have a historical link with the UK, said that under English law, the trustee has a unitary legal personality, which means that there is no distinction between a personal and fiduciary capacity. Now, you might say there is no distinction between a personal and fiduciary patrimony. So under English law, if a trustee takes on a liability as trustee and the creditors want to sue him, he may lose his own assets. So a trust does not limit the liability of a trustee. And I think that 37 years later, after the convention, there is an opportunity here to take into account recent judgment, again, to clean up a bit the wording of the convention, to make it more reflective of the legal position. The second opportunity is clearly to support the understanding of the trust mechanism, and conferences such as this are an ideal tool for that. We should also seize the wave of civil law trust initiatives. So if you look at China, Hungary, Israel, Japan, Korea, Switzerland, and in Latin America, there are lots of laws, a lot of them introduced after 1985, which seek to introduce trust laws, either labeled as such or as something similar. China is a very good example. It introduced a trust in inverted comma law in 2001. So I think that the Hague Convention could reach out to these jurisdictions. Switzerland is already a signatory country, but it could reach out to these states and tell them, look, you have now a new trust. Would you like to join the convention? And clearly, you know, the prospect of bringing China into the convention could have huge repercussions. At the moment, China is only a party by reference to Hong Kong, because the UK had extended the convention to Hong Kong. So I think it's pretty exciting stuff. And then we need to reflect global trends. I said earlier that as a matter of tax, there is now greater transparency on trust, but not only. So if you look at the EU Money Laundering Directive, it defines beneficial owners of corporate and trusts, and then also of legal entities which are similar to trusts. Also, if you look at the Common Reporting Standard, which, as I said, is a system by which countries exchange information to each other in relation to tax, trusts feature prominently, but then also there are references to structures which are equivalent to trust or functionally similar to trust, i.e. foundations. And again, they say trust and other similar structures. So I think that if we look at the convention at the moment, the explanatory report asks itself whether other structures should be included. And there is an Italian professor who came up with the idea of the shapeless trust. According to him, given that the convention does not contain a definition of a trust, but a description, he says anything that fits that description should be recognized. Now, the reality is that the explanatory report was quite cautious about that. And if you look at also the Vienna Convention on the Interpretation of Contracts, Article 31 says that international conventions should be interpreted by reference to the ordinary meanings of the word and the context. Now, everywhere in the Trust Convention and even the preamble, there is a reference to the common law trust. So we can either push the argument for shapeless trust to extend the convention to other institutions, or we can take stock of the developments that took place in the last 5 to 6 years globally, because the CRS involves over 100 jurisdictions, and we might say, look, dear jurisdictions, non-contractual states, there are 100 countries there that looks at trust and also other structures, for example, foundations. In the US, for example, 2 states introduced foundations. You also have foundations in Denmark, Germany, Sweden. In Denmark and Germany, for example, foundations are used by big enterprises, companies for succession planning. So I think that by the convention, the conference might knock at the door of member states, but also non-member states, and say, look, you have been looking over the past 5 years in a tax environment at trust and equivalent instrument. Why don't we have our convention extended to capture those instruments? And I think it would create greater certainty, which is very, very important also for tax. So I think there is a tremendous opportunity. And finally, trusts can play a very important role in the digital world. NFTs, assets which require value to be held in segregated pots, and trusts and purpose trusts in particular can be very valuable. So in the half an hour that I had available, I hope that I showed you where we got to from 1985 to today. There have been the convention is trailblazing. Every time I read the convention, it blows me away how lawyers from the civil law and the common law world could come together in The Hague and come up with this convention. Still marvels me 37 years later. However, there have been a number of interesting developments, both in terms of case law jurisprudence and in terms of regulatory and tax developments, that suggest that more can be done now to enhance the appeal of the convention and bring into the convention's fold non-member states, and we could also expand the remit of the convention. That's all from me. I think that it has been an amazing week, and I do hope that you delegates and also the conference will reflect on events of the last week. Thank you very much.